Hello. Thanks for taking a look at this week's module on the development of international law. The earliest known law is the Code of Hammurabi, a law that was designed by Hammurabi to put in place rules of cause and effect, consequences, if you will, and he had these etched onto these stones spread throughout his empire. Laws were developed for city-states, nation-states, empire states throughout time. Draconian law from King Draco in ancient Greece, the 12 Tables of Rome, the Magna Carta, the Golden Bull, the Declaration of Rights of Man and Citizen, the US Constitution. The list goes on and on, how nation states developed their written laws. Of course, other nations, perhaps non-literate civilizations, had laws, but maybe not written down. And certainly there's this principle that we're all aware of that when you're in charge, it's good to be king, right? So what we see develop, particularly out of Western Europe, particularly out of Britain, is slowly the unfolding of this idea that the leader of the nation state, shockingly, should actually follow the laws as well. So you have these two parallel tracks of development that leads to international law as it is today. First is the development of domestic law, the legislation that is espoused by the king or the developing parliaments in Western democracies, the idea that these laws have to be followed by the people, and eventually, particularly after the English Civil War, the idea that the king has to follow those laws as well. Parallel with that is this idea of the development of international norms. And specifically at the Treaty of Westphalia in the 17th century, what develops as the norm is the idea that nation states should not interfere in the internal business of other nation states. The principle that we get out of the Treaty of Augsburg and the Treaty of Westphalia is this idea of his rule, his religion, that the leader of a nation state gets to determine internal domestic policies. So again, these two parallel tracks, the development of domestic law and the development of international norms. Well, in the aftermath of the horrors of the American Civil War and the Crimean War in Europe, this new awareness of this concept of total warfare, which had been inflicted on civilian populations, not just belligerents, comes the need to codify what exactly the rules of war are. In the United States, that codification of law regarding the military is known as the Lieber Code. And at the end of the American Civil War, Henry Wirz of the infamous Andersonville war camp was put on trial and executed. In Europe, the Hague Conventions and later the Geneva Conventions set down the rules on how armies are to engage, navies are to engage, how civilian populations should be treated, how doctors and nurses should be treated, how prisoners of war should be treated, and the respect for neutrality in nation states that are not involved in conflict. In the aftermath of World War I, we have the Leipzig trials, where Germany, the new Germany, the Weimar Republic, put some of its war criminals, some of its own war criminals on trial. So we have this idea that some nation states are allowed to put their own perpetrators of war crimes on trial versus the expectation that the victors or the international community should put the people on trial who have violated the. Additionally, after World War I, we have the 14 points, the Treaty of Paris, the idea of self-determination and territorial integrity. We have the League of Nations and the Kellogg-Briand Pact, which outlaws war. That didn't work out. We got World War II. So during World War II, pretty much in 1943, the Allies knew they were going to win. The Nazis and the Axis powers had reached their zenith. And so the Allies began discussing how they were going to treat the expected losing states. And they developed the UN War Crimes Commission that set the foundations for what we know now as the Nuremberg Trials. And here became the standard that the international community has the right to put people on trial. In this case, it was the Allied powers who won, putting Nazis on trial in Europe, in the United, And in the Eastern Theater, the United States established the Tokyo Trials, where they put Japanese war criminals on trial. But again, I want to point out that was predicated on military victory. Okay, so later we have the Treaty of San Francisco, we have the establishment of the United Nations, we have the Declaration of Human Rights by the precursor to the United Nations, led by the great Eleanor Roosevelt. So there's this expectation that there are human rights that the international community recognizes, and therefore, if you violate those international norms and human rights, you are eligible to be put on trial by the international community. The first piece of legislation that in this area that the UN worked on was the UN Convention for the Punishment and Prevention of the Crime of Genocide. Eventually, that led to what we call the International War Crimes Commission for Rwanda and the International War Crimes Commission for the former Yugoslavia. And the expectation that it is up to, and not just the right, but it is the expectation that the international community will put war criminals, domestic or international, on trial. And that led to the Rome Statute, the Rome Treaty in 1999, which the United States signed, which created the International War Crimes Commission in a new manifestation, this called the ICC, the International Criminal Court. The United States did not ratify the Rome Statute, and so while the United States signs the treaty, we are not a party to the ICC because of this idea that the International Criminal Court can put domestic war criminals on trial. And that rubs some people in the United States the wrong way. The idea that American soldiers in Iraq, in Afghanistan, or around the world might be put on trial without the consent of the United States in the International Criminal Court. The other side of that argument, of course, is we do want war criminals in countries where we perceive their leaders or soldiers and commanders to have be perpetrating war crimes. We want those people put on trial. For example, the special trial in Sierra Leone, which convicted Charles Taylor, or the UN trial of the Pol Pot regime and the Khmer Rouge in Cambodia in the 90s and 2000s as well. So this brief lecture was to discuss the origins of law, the two tracks of the development of law, international and domestic law, the idea that the leaders of a nation state should be held liable to their own nation states' laws, and also that nation states and leaders of nation states should be held liable to an international norm expectation like the Hague Conventions, the Geneva Conventions, and the United Nations Declaration of Human Rights. So I hope you are excited about this module. My suggestion would be that once you look at the overview, I want you to then choose a specific genocide of the 20th or 21st century, and I want you to choose readings specifically on that genocide that you choose, just as another way to make this your curriculum and empower you to study what you want to study. And it also makes the discussion post a little bit interesting when people are studying different genocides in order to understand the material in this module. Thanks so much. Enjoy.